So we just got some massive news out of the Supreme Court, and it's something that I had predicted and been talking about for the last year plus. And that's the fact that the Supreme Court has just granted review to the ATF bump stock ban case. The case is Cargill, which means that the Supreme Court will decide during their next term if they want to end the ATF's current overreach and their ban on bump stocks, and this will impact all other cases with ATF overreach, like the pistol brace rule, the frames and receivers rule, and so many other things. So let's talk about what's going on. But real quick before you jump into this video, if you think all of these ATF rules need to be struck down, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee, and they are huge Second Amendment supporters. They have dedicated roasts for organizations like FBC and GOA, so if you want great coffee and you want to support the 2A cause, you can check them out using the links down below, and if you use the code ARMSCHOLAR, you can get 10% off of your order. So as I mentioned in the intro, we got some huge news today and some amazing news, and that's the fact that the Supreme Court has just granted review. They just issued an order granting cert to the next big firearms case, which is the challenge to the ATF's bump stock ban. The case that they're reviewing is this ATF bump stock ban, and this case that came out of the Fifth Circuit, which is the Cargill v. Garland case. It's something that we've been tracking for a while. I've been tracking this case probably before many people have even heard of it, or we're even making videos about it. We've been talking about this case for a long time, and that's why we do this, because these cases are important. You have to follow them through the process, and now it's all coming to a head with the Supreme Court granting review to this case. As many of you know, we received a major Second Amendment win coming out of the Fifth Circuit Court of Appeals. The Fifth Circuit en banc panel ruled in the Cargill v. Garland case that the ATF's final rule on bump stocks is in fact invalid. That decision struck a major blow to the ATF's current overreach and their claimed authority that they have to make these types of restrictions. In this important decision, the Fifth Circuit en banc panel found that the definition of machine gun as outlined in the NFA and GCA does not apply to items like bump stocks. This case has major implications not just for bump stocks, but it will also likely impact other ATF rules, like their rule on frames and receivers, their pistol brace ban, their current restrictions on forced reset triggers. And so this is very important. It's going to set a stage for a lot of cases, a lot of movement coming into this next year, 2024. Now, for those not aware, the Cargill case involved a direct challenge to the ATF's rule, which suddenly regulated and banned bump stocks under the assumption that the items were now magically so-called machine guns. For many years, the ATF had stated that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the incident in Las Vegas, the ATF, after being directed and ordered by President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be machine guns magically under the definition of the GCA and NFA. One of the important aspects of this challenge was whether or not Chevron deference should be given to the ATF in relation to their final rule on bump stocks, or whether another rule, called the rule of lenity, would direct courts to rule in a way that is most favorable to the people, not the agency, the ATF. If you're not aware of what Chevron deference refers to, Chevron deference is a term coined after a landmark case referring to the doctrine of judicial deference, which is given to administrative actions. Generally, for an agency like the ATF to be given Chevron deference, the agency's interpretation of an ambiguous statute or term must be rational or reasonable. So when a statute has ambiguous terms, allegedly like terms like machine guns, then the agency like the ATF responsible for enforcing that statute may be able to determine what that term was intended to mean if their interpretation of that ambiguous term is rational or reasonable. In contrast to Chevron deference, there is another rule called the rule of lenity. And the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a way that is most favorable to the people, not the enforcement agency. Now, this case eventually made its way to an en banc panel review in the Fifth Circuit, and in a 13-3 decision, the en banc panel in the Fifth Circuit found that the ATF overstepped its authority in regulating bump stocks as machine guns under the GCA. The court in that opinion stated that a plain reading of the statutory language, paired with close consideration of the mechanics of a semi-automatic firearm, reveals that a bump stock is excluded from the technical definition of machine gun set forth in the GCA and NFA. In the decision, the Fifth Circuit en banc panel clearly identified that the definition of machine gun in the GCA and NFA does not include items like bump stocks. And they stated that even if the term were considered ambiguous or vague on that issue, the court concluded that the rule of lenity would direct an interpretation in favor of us, the people, and the interpretation would be that bump stocks are not machine guns. And then they stated that if Congress or the ATF wants the definition to include these types of items, then they need to change the statute, but the ATF does not have the power to do that on their own. Instead, a change in definition needs to be done by Congress. Now, we mentioned a different case, which is the Hardin Sixth Circuit case, and then also the Guides case. Both of those are currently pending for Supreme Court review. They are kind of sitting behind the Cargill case. They might be consolidated with Cargill, or they might just be put on hold. So that's going to be interesting to see what happens. But in the Sixth Circuit, in the Hardin case, the court came to a similar conclusion, but they did use a different approach. In the Sixth Circuit Hardin case, the court there stated and kind of started from the position that the term and statute is in fact ambiguous, and therefore they moved on to see what the doctrine should be used, whether or not you would use something like Chevron, or would you use the rule of lenity to try to clear up that ambiguity. They then decided to use essentially the rule of lenity and not use Chevron. In contrast to those two decisions which were positive against the ATF did get one case that they won, which was the Guides case out of the DC Circuit Court. And this set, again, a circuit split, which is very important that you need oftentimes to get Supreme Court review. And again, after the Fifth Circuit issued their decision in the Cargill case and struck down the bump stock ban, the ATF had to file for Supreme Court review. They wanted review of that decision because they could not let that sit as precedent in the Fifth Circuit. And in that petition, the question that the ATF submitted to the Supreme Court for review was whether a bump stock device is a machine gun as defined in 26 USC 5845 subsection B, because it is designed and intended for use in converting a rifle into a machine gun, i.e. into a weapon that fires automatically more than one shot by a single function of the trigger. So in this case, that is what was presented to the Supreme Court, and both sides argued that they needed Supreme Court review, that they needed review of this decision, and both sides were in agreement that the Supreme Court should grant cert. And again, this went to conference last week, and the Supreme Court today issued their order, and the Supreme Court in their order list stated that they have granted cert, aka they have granted review to the Cargill bump stock case. This is huge because now we will truly find out if the Supreme Court is going to, if they're willing to, strike down the ATF's current overreach with these types of rules, like their bump stock ban, like their pistol brace restrictions, like their frames and receivers rule, the force reset trigger restrictions, and all the other things that the ATF is doing. We will truly find out what the Supreme Court's mindset is on that type of overreach. And the decision will impact all the lawsuits which are currently challenging those rules, and no doubt any language in this Cargill decision will then be pulled in those other decisions, like the Mock case in the Fifth Circuit challenging the pistol brace rule. Now, for those who are curious about what happens now that the Supreme Court has granted review, well, the Supreme Court will first issue a briefing schedule. A lot of briefs will be submitted, some replies, responses, amicus briefs will be filed also as well in this case, and then oral arguments will be set, and those will often be set for sometime next year, still before the end of their next term. So we will get a decision from the Supreme Court on whether they will actually strike down the ATF's bump stock ban, and that decision will come before the end of their next term, which is in late June or early July. And just it really depends on when they hear the oral arguments in this case, and then ultimately when they want to release the decision. Sometimes they release more controversial decisions like this one. They wait till the very end. They did that with the Bruin decision. They do that with a lot of other cases. So we may actually have to wait until the very end of their term to get this decision. But regardless, it is going to be coming very soon. This, coupled with the upcoming decisions on Chevron deference and some of the other cases like the Raimondo case that we've talked about here on the channel, a lot of those cases challenging Chevron deference and whether or not the Supreme Court is going to completely strike it down or at least handcuff it dramatically. So we have some Chevron deference cases coming up this next term or this term. And then we also have the Rahimi case, which is set to be argued this upcoming week. And all of this, the Cargill case, the Chevron cases, the Rahimi case, all of this coupled together during this term can really set the stage for a very significant pro-2A kind of wave in 2024 and just set the framework going forward to really stop a lot of this current violation about our Second Amendment rights, current ATF overreach, and just a lot of the things that have been going on even after Bruin. So if you guys have any questions, go ahead and comment down below and I will try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Also want to mention that you might just want to double check your subscription. A lot of people comment almost every single day that they've been unsubscribed from the channel, so just double check that. And then also, if you're not currently subscribed to the channel, please consider subscribing to the channel and share this video around to your friends, because one of the best ways to grow this two-way information, to grow this type of channel, is just by word of mouth. So share this with your friends. But regardless, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.